So I wanted to talk about OUI cases in Massachusetts, and oftentimes when I meet with people with an OUI charge in Mass, they tell me that they have children and a family and a mortgage and a job, and why won't the government consider all that and do something with the OUI other than an OUI sentence? And the answer is there's only two things that you can do with an OUI in Massachusetts. You either admit to it and plead it out and you receive the mandatory minimum sentence, which everyone gets on a first offense, or you fight it. And there is quite literally nothing in between. Those are your two choices. And just by way of an example as to why you should fight an OUI case and show up with a lawyer that's ready to try the case, I had one this week where a woman had a minor fender bender on her way home. She left the scene of that accident, was found by the police a few minutes later, was arrested after doing horribly on the field sobriety test, and she blew a .24 breath test. Now, most people and most lawyers probably would have looked at that case and said, this is fairly hopeless. You should plead out, and you're going to have the OUI in your record for the rest of your life. I took the opposite approach. I knew going in that the .24 breath test was going to be excluded as evidence because of what was going on with the machine at the time. And then I proceeded to a trial, and I insisted upon getting all of the available discovery, witness information, and most importantly, the booking video. And before the first trial date, I discovered that the booking video was not provided. They had inadvertently given me jailhouse recordings of another defendant in another case. It wasn't the booking video, it was something else entirely. So that first trial date had to be continued so that the government, the prosecution, could get me the booking video. We went back for a second trial date, and again, all the government's witnesses were there, the police witnesses, the civilian driver that was struck, and again, still no video. And I was insistent that you have to give me the video in order for me and my client to be prepared for trial. Right before the third trial date, again, I realized that they still had not yet provided the booking video. I prepared a motion to dismiss for failure to produce the evidence. I showed up for a third trial date, ready to go to trial, and lo and behold, the civilian witness was not present, but the police officers were, and the judge not only granted the motion to dismiss for failure to provide discovery, but she also dismissed the charge for lack of prosecution because the government was not able to go forward without that civilian witness. It was the third trial date, and all those prior continuances were due to the Commonwealth, the government, the prosecution not being ready to go and not providing the information that they were supposed to. So what started off as what many people would have viewed as a hopeless case ended up in a dismissal of both the OUI charge and the leaving the scene charge. And now my client is not burdened with that OUI finding on her record for the rest of her life. And that is why, if you're going to have an OUI case before any court in Massachusetts, you hire a trial lawyer. You don't run out and hire the first lawyer that you find for your arraignment. If you're going to get in a rock fight in the courtroom, hire a trial lawyer.